personal representative is usually a person carefully selected during a person's lifetime to carry out the administration of their final needs when they pass away. Personal representatives might be an individual and can also be an attorney, bank, or trust company, any of whom must be appointed by a Florida court to be in charge of a deceased person's Florida estate matters. Choosing a personal representative is an integral aspect of most estate plans, and holding the position is not a light undertaking. Hello, I'm Carlina Hull, a probate attorney here at Elder Needs Law. Because of the utmost significance of the personal representative's position, Florida law states that, except under very limited circumstances, a personal representative must be represented by a Florida bar licensed attorney. The attorney for the personal representative files all probate court documents on behalf of the personal representative, advises them on all responsibilities and legal duties, and represents them in all estate proceedings. It's very important to note that the attorney for the personal representative is not the attorney for any of the estate's heirs or beneficiaries, or for the estate itself, and the personal representative may usually select the attorney of their choosing. A personal representative must either be a Florida resident or entity, or regardless of residence, must be a spouse, sibling, parent, child, or other close relative of the decedent. They must also be over 18, not a convicted felon, and of sound mind. Once a probate estate is opened in the appropriate Florida county, the court will formally appoint the personal representative and supply them with letters of administration. Letters of administration are judge-signed official court orders which permit the personal representative to go about the business of administering the decedent's estate according to Florida law. The appointed personal representative and their attorney work to properly gather, identify, and safeguard the decedent's assets. They must also provide notice to and diligently search for any reasonably ascertainable creditors or debt of the decedent. A personal representative must also serve notice of the estate's administration upon all interested parties to the extent that they can be found and contacted. This includes any named beneficiaries and any likely heirs if the decedent did not leave a valid will or trust. The personal representative pays all valid expenses out of the estate's assets and ensures that any state or federal tax matters are taken care of. They also pay any valid creditor claims. And the final responsibility of the personal representative, and often my favorite part of being involved with probate matters, is to distribute the remaining assets to the beneficiaries. Once distributions have been made, the personal representative ensures that the estate is properly discharged before the court relieves them of duty. When a loved one passes away with Florida assets, settling their estate will benefit from and usually requires a Florida bar licensed attorney. Probate administration by a personal representative is a sophisticated endeavor that requires familiarity with complex Florida law. Here at Elder Needs Law, we provide individualized probate services to meet the needs of each family, and we'd love to hear from you soon.